Hello everyone and welcome to today's Mondac webinar in association with Steptoe and Johnson LLP, discussing asset recovery and judgment enforcement with a focus on the US and new trends with a perspective from the UK. My name is Dan Sampaio and I'm joined by a wonderful panel to take us through today's discussion. But before I hand you over, a quick housekeeping item. You can submit questions to today's panel by typing them into the questions pane of the toolbar on the right-hand side of your page. The panel will endeavour to answer as many questions as possible during the Q&A session, but please do reach out after the webinar for any additional information you may require. It's now my pleasure to hand you over to Stephen, Michael and Chris to begin. Thank you.
Thanks, Dan, and good morning and good afternoon to everyone. Thank you very much for joining. My name's Steve Davidson. I'm a partner at Steptoe and Johnson, where I am the co-head of our commercial litigation and arbitration practice groups. With me is my colleague and partner, Michael Baratz, the other fellow in the tie, who has worked with me for many years on judgment enforcement and asset recovery. I've been doing this line of work for more than 30 years. I know I look more youthful than that, but it has been well over 30 years now. And with us is another colleague, Chris Weil from the Mintz Group, who's a partner and head of the disputes practice, who is a specialist and experienced practitioner in finding the assets and helping and basically making lawyers look good when we find the assets and have a happy client. So as you've seen and have heard, today's topic is asset recovery and judgment enforcement, with a particular emphasis on some of the trends in the US and the UK. It's a very, very deep topic. We'll go through the slide deck we have and try to hit all the topics we have in front of you. And we'll, as Dan said, we'll leave a little time at the end for Q&A, and we'll deal with the questions at the end rather than interspersed throughout. So if you could go to the next slide, you'll see the overview of what we hope to achieve here. And we'll go through this as best we can. As I said, it's a lot of material to cover. We'll probably hit the highlights of things, and hopefully we'll all be better for it, particularly with your questions. Next slide. So the most important thing in asset recovery and judgment enforcement is having a well-designed plan. I always tell people that a piece of paper saying how great you did in a case is wonderful, and clients are appreciative, but the appreciation for that runs off quickly when they then say, okay, well, where's the money? So like our theme of this is a check or an airplane or an apartment or gold bullion or just payment is far better than a piece of paper. The kind of cases we're going to talk about today and the situations that present themselves are where you have a recalcitrant debtor. You have a judgment and they're not paying. And some of them might have concealed their assets, and you have to try to find them, untangle them. There's oftentimes in an intricate web of offshore entities, indirectly owned enterprises, and it requires a lot of thought, a lot of pre-planning, and sadly, for you clients out there, a lot of patience and often a lot of investment to try to get your recovery, which is why this headline of having a well-designed plan and assess the merits of what you can do is very important. And the third bullet there, investigators and lawyers working hand in hand best from the beginning. We often get cases where people haven't done that, and they've tried to enforce their judgment in jurisdictions that didn't have any assets, and they missed ones that did have assets. And you really need to be careful in your first steps and think through where you're going to go, because eventually your client is going to lose patience and perhaps become frustrated at the amount of investment that's being made in this endeavor. And you really have to be thoughtful and use your assets meaningfully from the beginning. So if we can go to the next slide, go finding the assets before you start. And then at this point, maybe Chris can talk a little bit about sort of what to do, the do's, the don'ts, the first do is hire Chris, but beyond that, Chris can tell you in more detail sort of what to do next.
So, as Steve, I think, said, this is, when you do asset investigations, we get brought in to investigate debtors' assets throughout the life cycle of a case. It's all about building a roadmap. You know, and we come in from either an anticipated action, where we're talking here, where the creditor needs to know whether a debtor's pockets are deep enough even to file a claim, let alone to satisfy an eventual award, to the post-award scenario where a client may be scrambling to enforce a judgment and or force the debtor to the table. And what I say, and I think we're in full alignment here with Steve's notion, is that getting investigators in early to be able to map and build a plan is key. And aside from a funding issue, and certainly every funder you go to is going to want to know where how a claim and an award is going to be monetized. The work that's done early builds this map for eventual enforcement. You need to know how a debtor holds their assets and makes their money, and then where the assets of the revenue streams that hit jurisdictions that actually can be favorable to an award creditor. The thing that's important about taking this picture early, is it is kind of a natural set. It is the picture before panic sets in. The case moves on. You may actually see efforts at dissipation, restructuring of assets. It's kind of day zero, and then as the case goes on, that's where things get complicated. And what I say to clients often is that doing this picture early is more cost effective and helps, again, inform the broader legal strategy for moving forward. When it's done at the 11th hour, all of that foundational work has to be done, and then you need to, again, back things up to see what has transpired during the course of the proceeding. And that's
a really, really good point. And then, you know, Michael, maybe you could talk a little about, because in a lot of our cases, you want to think about it when you get the case. You know, how are we going to get paid? And a lot of times people don't do that.
That's certainly true. And thanks, Chris and Steve. It's a pleasure to join you and everyone on this panel. If you know your judgment debtor ahead of time and you can get the assets ahead of time, then what often is the biggest question or disappointment of show me the money at the end of the road is already taken care of. And that often can lead to significant leverage and or settlement. But sometimes we don't get started right away. And when that happens, when you have your judgment or you've had good lawyers who know the subject matter and have litigated it to a judgment, you can often team up with firms like us or others who really know the judgment enforcement area. The only other point, if you know from the beginning, as Chris said, lots of times there will start to be transfers or dissipation of assets. And the sooner you can identify those entities and start to go after them or watch them to see where the money goes, the better off you'll be to get a full recovery.
Right, because, you know, we've been brought in at all different kinds of procedural postures of cases, sometimes right from the beginning before a judgment's been obtained. And at that point, speaking to the lawyers out there, it's really critical to give your client an honest assessment of how they're going to get paid, because as you all know, getting a judgment, taking it through trial is expensive. And, you know, with a lot of our cases that we're in as lawyers, you know, payment's not really an issue. It's between two sizable entities. You know, whoever loses is just going to, you know, wire the money to the winner. But in a lot of other cases, even from the beginning, that's not the case. And you have kind of a suspect defendant. You're not really sure if they're going to be able to pay. And you really need to talk to someone like Chris at the beginning, because, you know, if you're halfway through or at the finish line and you've got a judgment, and then you sort of come to look at, well, is there any way to pay this? You know, it's really too late. because as Chris and Michael said, if you're dealing with someone who is nefarious, oftentimes during the case itself, they'll start squirreling away their assets and making them hard to find. So getting somebody like Chris involved early and thinking through these issues before you even commence the litigation to make sure you have a viable claim of recovery is really essential. And go ahead. I'm sorry, Chris.
Oh, no, quite all right. The only thing I would add to that is, I think there is certainly a statistical commonality between recalcitrant debtors and those that are usually more sophisticated in structuring their assets, the equivalent. The thing that we often do when we look at this work, we obviously are looking for assets that have actual monetary value that would satisfy an award. But the other piece that you should never forget is there's also a disruption value that is attached to certain assets. And even if they, can't satisfy all the zeros attached to a judgment, they may be integral to the day-to-day affairs of a debtor. They may be embarrassing to the debtor if you actually go after them. Someone loves their show ponies. I don't care how much that satisfies. That might actually get them to the table.
Right.
So there are different values attached, and part of this mapping exercise that we're talking about here is a way to ensure that you're capturing both of those. The other thing about these investigations, which will, I think, anticipate places we're going later, is in addition to actually identifying the assets, identifying the structures that hold these assets that the debtor controls, is knowing where the information sits. And this is where, even if you don't have something that, again, gets to the dollar amount of an award, knowing where you would go after for disclosure, where you would go after for discovery, and knowing who knows what is going to help, again, define the plan moving forward as you move into an enforcement stage.
Yeah, and that's I wanted to just follow up on one of the points Chris made that's particularly important, which is when you go through this process, the best way to get paid is to make yourself sort of as annoying as humanly possible within the bounds of, of what you're allowed to do under the law and as lawyers to the debtor. I mean, Chris said, go after that asset that's really important to the debtor, even if it's maybe not the most valuable. Make yourself present to the debtor in a way that they think, they're never going to go away, and they just took something that's really important to me, and I have to find a way to deal with this. Because in a perfect world, although it's fun for us to seize jets and yachts and things like that, in a perfect world, for your client's sake, you get the debtor to a point where they say, okay, enough, I'm just going to pay you. And that's where we want cases to end up. And employing the strategies that Chris and Michael have talked about is in many ways the best way to get there. So if we go to the next slide, let's talk about, some of the more nuts and bolts of before you start on what your potential remedies are. And we've done this through U.S. pre-judgment remedies, and then in the UK, in the courts of England and Wales. And these are not every possible remedy that you could think of or perhaps seek pre-judgment. And in the United States, this varies significantly from jurisdiction to jurisdiction. These big international cases are typically in federal court because of diversity of citizenship. But even within federal court, you use the underlying state law when it comes to judgment enforcement remedies, both pre and post judgment. So you have to be careful and look at the law of the state you're in, because via the federal rules of civil procedure, you look to the state law. So we have a list there of U.S., and maybe Michael, you could sort of hit the highlights and run through some of our playbook here.
Yeah, sure. So on the U.S. side, I think the most important thing to remember is that it's almost all of these remedies are pointed to a specific asset. And you can get these pre-judgment. Many of them you can get ex parte. There are different factors depending on which state you are in. It's not always necessary to show that there's a risk of dissipation in the United States to get the attachment, if you have a contractual claim, if you have a liquidated sum, if the debtor doesn't reside within the state. These are factors that often will justify prejudgment attachment, although in almost every case you need to show a likelihood of success on the merits. There are some, in the cases of fraud and others, where you do have to show a risk of dissipation of assets. But the major distinction between U.S. relief and UK relief, which I'll turn back over to Steve, is that in almost all cases in the United States, you are freezing specific assets. You are not, in most cases, getting a general freezing order that precludes the debtor from transferring their assets, which is in substantial contrast with the United Kingdom.
Right, and we have another slide on this, which we'll go through again in more detail, but the UK in the courts of England and Wales have very powerful pre- and post-judgment remedies. Pre-judgment, I'm sure most of you have heard about the worldwide freezing order and domestic freezing orders, previously called Mareba injunctions in the United Kingdom. And that's because that was the seminal case that led to the application of this doctrine, which has now been codified by statute. So we now call them freezing orders. And you can see on this slide the elements of what you need to prove, that there's a cause of action, a good and arguable case, and that there are assets within the jurisdiction, which is typically said in jurisdictional parlance as a sufficient connection to the jurisdiction. And this last one, the last two are really the ones that most of the litigation is over, that there's a real risk of dissipation of those assets without the freezing order, and it's just inconvenient for the court to exercise its discretion. The second to last bullet is often satisfied if you have a judgment and you're seeking a freezing order and the judgment hasn't been paid. But if you're going pre-judgment, it's often quite a factual battle about whether there's a real risk of dissipation. You have to show, some sort of conduct by the debtor which gives rise to a judge being able to conclude that the debtor without this relief is not likely to satisfy the eventual judgment. And that last factor is more of a kind of equitable, in some ways, balancing act of the different variables that are in play in terms of whether it's proper to grant this order. And if we can go to the next slide, please. We have a little bit more on this. It's an important thing to remember is if you're going against a debtor that has assets worldwide, you really should think about going to England. The freezing orders there are, as Michael said, different than in the United States and frankly most other countries where freezing orders, particularly pre-judgment relief, are only attainable against specific assets, like where there's a bank account, an apartment, some other kind of tangible or intangible asset that you can get an order against. The English freezing order is more of a general injunction against the debtor with respect to its assets. And it can be very powerful, and it commands the debtor, if you get a worldwide freezing order, to freeze assets even outside of England. It has significant disclosure remedies. It has potential contempt as a remedy, because often in these cases, you get this, debtor refuses to comply, and then you get more sanctions and contempt fines and payments. And in some cases, we've even had imprisonment against a recalcitrant debtor for refusal to comply with disclosure order. And also, unlike most other jurisdictions, England allows for alternative service methods. And there are also domestic freezing orders that only apply within England that have a less stringent test. Now, one thing to remember here, though, is that this litigation, not so much getting the freezing order, because that's done on an ex parte basis, but remember, under English law, you have a duty of full and frank disclosure, which means, if there's some, potential problems with your case, you have to disclose those to the court in order for the court, and if you don't, there's severe sanctions for that. But the litigation usually in this is after you get the freezing order. and the other side comes in and tries to set it aside. And that can be very expensive. It's done on a pretty quick basis. Usually even a complicated one of these is decided within a couple of months of when you get the freezing order, and sometimes even more quickly than that. But remember, England's a loser pays jurisdiction. So if you go to get one of these, you get it ex parte, and then you lose it on a inter partes basis, it can cost your client a lot of money. That's not a reason not to do it, but you have to really be confident that you're going to win. But it's a very powerful tool and should always be considered when looking at a debtor's assets. So let's go to the next slide, and then Michael's going to talk about recognition of foreign judgments in the United States, which is a unique and somewhat peculiar endeavor as compared to recognizing judgments within European countries, for example.
Yes. Some of our international clients are surprised that the United States is not party to any bilateral or multilateral treaties for the recognition of a judgment within the United States. At the state level, there are uniform acts that codify the common law for recognition. And at the federal level, it is either federal common law or sometimes the federal court will apply the state statute. There is an international convention on the recognition of enforcement of foreign judgments in civil or commercial matters that is floating around out there. While 33 countries have signed, most of that is the member states of the EU. The United States has signed the treaty, but it's not been ratified. And as any casual observer of the United States knows, the United States Senate has not been quick on ratifying treaties. If that convention came into force, it would be the first multilateral convention that the United States has signed for the recognition of a judgment. Now, that is different than arbitration awards. Both bilateral investment treaty awards done under ICSID or commercial international arbitration awards that would fall under the New York Convention, those awards are governed by treaty and are recognized by the United States. When it comes to comity in the United States courts often will recognize foreign judgments here, even if the judgment has not yet been recognized in that foreign country. While reciprocity is usually the first element that people think of, most courts are aware that U.S. court judgments do not receive the same reception outside the United States, often because of our jury system, and default judgments are typically not recognized outside the United States. So even without reciprocity, what the court will really look to here to recognize a foreign court judgment is, was there personal jurisdiction over the defendant, and is there any appearance of fraud or collusion or a violation of public policy? It is relatively easy to get a foreign court judgment recognized in the United States. Going the other way is a different scenario.
Yeah, let me give you a few thoughts on that. In terms of getting a foreign judgment recognized in the U.S., as Michael said, there is most states in the United States have passed the Uniform Recognition of Foreign Judgments Act, which basically sets forth those 4 prongs of a test to have a foreign judgment recognized in the U.S. It has to be done on in court filing a new claim, so it takes a little while. Not necessarily years, but certainly months. And if you have a good judgment from a country that is well known to have a transparent and sort of worldwide accepted judicial system, you can typically get it done, but it takes a little while. In terms of going in the other direction, a U.S. judgment to a foreign country, the standards applied in the foreign countries are roughly similar to what we have on here on the comity, with some extra factors. Like, for example, in England, in order to have an American judgment recognized, you have to prove that the judgment defendant in the U.S. submitted to jurisdiction. And submitted is a term of art, which often means, it can mean consent and can often mean litigated and lost, but there's sometimes room for a debtor, a judgment defendant, to argue that he or she did not submit to the U.S. jurisdiction. So it's, it's something that can be done. It's not simple like using the Lugano Convention in Europe. It requires a judicial action and proof of certain factors. And oftentimes in particularly going U.S. judgment the other way, you often need an expert on American law in order to make this happen. So let's go to the next slide and talk just for a minute about certain special circumstances going against sovereigns. As we all know, this litigation has really become more prevalent in the last decade or so. There have been some very notable sovereigns that have defaulted and not paid awards, and some of them have even defaulted on their bond offerings, notably Venezuela, some other South American countries. And in the United States, the sovereignty is governed by the Foreign Sovereign Immunities Act, a federal statute. And, at common law, a sovereign was not suable. So what has happened over time is that common law has been modified by statute so that sovereigns can be sued. And in the United States, the most typically available exceptions to immunity that are found in the Foreign Sovereign Immunities Act are the ones we have on this slide: waiver, participating in a commercial activity, or recognition of an arbitral award. And waiver, for example, a lot of times in these bond offerings or other commercial contracts that a sovereign or a sovereign entity participates in, there's a waiver to some degree of sovereign immunity that allows for the sovereign to be sued. Commercial activity is a specified exception under the Foreign Sovereign Immunities Act that basically, if a sovereign is acting like a commercial player rather than a sovereign, this can be done. There are certain other bells and whistles that go with this in terms of where the activity occurred and what impact it has, if any, in the United States. Another one is a violation of international law, which also requires certain additional factors like an impact in the United States. Now, one thing that's very important to remember, and clients are often frustrated by this, is that pre-judgment remedies against a sovereign are very, very difficult to obtain in the United States. That requires an express waiver if it's the sovereign. If it's one entity down from the sovereign, that is a state-owned entity, it can be an implied waiver, which we have used to our advantage, finding an implied waiver against a sovereign entity that's owned in whole by the sovereign. Because if there's an agreement to arbitrate and the rules allow for pre-judgment attachment, you can somehow do that. We were able to do that against a Venezuelan entity, PDVSA CN, in a case that became fairly noteworthy about 10 or 15 years ago in the Southern District of New York. And then on post-judgment enforcement, you need the court's permission, and only commercial assets are available for execution. That is, you can't attach the sovereign bank accounts, and you can't attach, embassy property and the like. And in terms of sovereign immunity issues in other countries, again, that's dealt with by statute. And generally, the law is not terribly dissimilar from America, but I would say it's, especially in England, a bit more permissive in terms of what you're allowed to do, in terms of pre-judgment remedies. In terms of the kind of assets you can go against, generally speaking, Western law is that it has to be non-sovereign used assets in the sense of sovereign bank accounts and that are used for a sovereign purpose, sovereign bank accounts that are used for a commercial purpose, if you can prove it, you can get at, and embassies and the like are not attachable really under any law. So if we go to the next slide, let's talk a little bit about judgment enforcement tools in the U.S. So this is when you have a judgment, you've got your piece of paper, and you want to turn it into money as against a recalcitrant debtor. So maybe Michael, you could give a little overview of this, and then maybe Chris, you can talk about sort of from the investigator perspective, what do you do?
Sure. So the U.S. discovery tools are very, very powerful. Often abroad we hear, oh, it's just a fishing expedition. But when you can turn that broad power that is governed by attorneys with some court supervision and working hand in hand with the investigators, this is where it can become very powerful. Once you have a judgment, you are entitled to full asset discovery. And 2 points I'd like to highlight on this slide. First is that we've had a lot of success asking the court for ex parte discovery. And often discovery, like any other court proceeding, you need to provide notice to the judgment debtor. And here you're always looking for documents or records about assets that are in the past, bank statements being a prime example. If the debtor knows exactly where you're looking or that you're on to a lead of their assets, they'll just always be a step ahead of you. And many courts have agreed that in certain circumstances, you can have delayed service so that you get the head start and advantage. If you're going to do that and you're serving discovery on a third party, it's really important to have the gag order apply to the third party as well, so that the judgment debtor doesn't get notice of your investigation efforts. The other is that many people will ask, well, why even serve anything on the judgment debtor at all? They'll never respond. But opening up contempt power for failure to go for assets, or if you are looking for certain factual information to support fraudulent transfers or piercing the veil against third parties, even in the post-judgment discovery context, a failure of the debtor to respond can lead to adverse inferences. That is, a failure to respond to discovery means that the court will infer that the answer was actually against the judgment debtor and that the entity is a alter ego and or received the debtor's assets without adequate consideration.
So Chris, maybe, so now we have a judgment.
Sure.
The lawyer at this point, you've been involved in the case, and now we're working hand in hand, like in one of our cases, and say, okay, help me out here. We've got these broad powers of discovery to go after the debtor. What can you add? What should we do?
Certainly. So the initial phase where we map assets is one thing, but then being able to understand the operations, the business affairs of those either companies and the holding structures becomes very important. Understanding their financial infrastructure, so knowing where they bank and how they pay their vendors, how they pay other third parties, the people who had touch on the operations of a company. So often we start pulling together lists of everything from registered agents, accountants, others that may hold information. And then, excuse me, the financial infrastructure piece can become very important. So knowing even, again, the sales channels of a company can become important. So who are they selling to, and what information resides within those customers, and how much do those customers owe your debtor? And in general, one of the things we always try to put out front is trying to find revenue streams that are unencumbered. When you're dealing with other asset classes like real property and other things, there's a good chance that you may not be first in line. Whereas if there is a clean revenue stream to a debtor, that may be one of your best places to look. And I've said this in many contexts, and I will say this here. I think one of the most powerful investigative tools we've gotten our hands on in recent years is a company called Gray List Trace, which allows you to legally identify banking relationships across the world. And what they do is essentially, if you have a debtor's email, you can search it against the mail exchange servers of almost 250,000 banks across the world down to the branch location. And so, again, this doesn't immediately mean you know the dollars and cents that are in those accounts, but as a discovery tool, what it does is narrow the entire world down to specific jurisdictions and specific banks that may have information regarding your debtor.
And that's a great point. If we go to the next slide, let's take what Chris just said and said, okay, how do we, he's given us this information, what do we do with it? And Michael talked a moment ago about the discovery, which may have give us some help, but I know this is, you know, maybe hard to believe, but the debtors aren't always honest in their answers, even under oath, of where their assets are. So we have to kind of force it out of them. And if we get the information that Chris gave us, that's very helpful. But then if you look at these judgment enforcement tools, we have some ways to try to force it out of them. And what we have found is that sometimes you don't know exactly where the bank accounts are or in which bank they are in. And there's no problem, like if you take New York and you want to serve writs of execution at as many New York banks as you can think of that mentions the debtor and says, freeze any money there. And if they freeze money, they're required to tell you that they froze money. So you can sort of, and it really doesn't take that much more time and money to generate these for multiple banks. You know, sometimes there's service rules you have to use and so on. But you really want, a lot of times you don't know where it is and you have to try to find the bank. Now, something that someone like Chris can really help you with is to try to narrow down the jurisdictions that you're looking at. Now, you know, it's typical that debtors of any consequence have some banking relationship in either New York, London, or Switzerland. And New York and London are easier to deal with on these writs of execution, or as they call them in England, third-party debt orders. Switzerland, you can get these orders as well, but it's a little more difficult, and it's more difficult to sort of hit the whole field with all the banks. You really have to have more of a basis with respect to each bank. But it's a very effective way, and it's a significant tool to try to get at these assets. So, Michael, maybe you can add on to that.
And just add on one more point. Of the banking centers, especially looking at the Asian market and Chinese companies where there are currency restrictions, you can often look in Hong Kong and Singapore for banking, just like in New York, London, and Switzerland or other European countries. And as of now, Hong Kong still has an independent judiciary that's recognizing judgments, and both Hong Kong and Singapore follow the UK model as former territories of the UK. In general, you are looking for, this is also very asset specific, and once you've identified either property that belongs to the debtor or debts that are owed to the judgment debtor, you can use these tools to actually execute on the asset. Many times, cash is obviously just cash, but many times when you're talking about an asset, whether it be an apartment, a boat, some other personal property, you have to go through an auction process to liquidate that into cash to satisfy the judgment. And judgment creditors can often credit bid and obtain that asset and then sell it on the market if the auction is not going well. And then there are obviously the chasing after the assets in the hands of third parties, whether it be a fraudulent transfer where the law views it as still the debtor's property, just in the hand of a third party, or whether there is an alter ego or some other corporate entity that in effect was set up for fraudulent purposes, where you're now getting a new finding of liability, and that other entity under veil piercing is equally liable for the judgment.
Thank you. And the other point I would add is that there's a word that some of you may not know called poundage. And remember, in different jurisdictions, a lot of these tactics often have to use a local law enforcement official. Like, for instance, in New York, it's a sheriff that often has to serve these levies, and the sheriff gets what we call poundage, which is what, 10% or 5% of what you can recover. So one thing we've tried to do, and sometimes we're successful with it, is if the United States Marshals serve it, the federal system doesn't have poundage. You don't have to, so you don't lose part of it. But if you have the sheriff do it, and sometimes you have to, and obviously 90%, 95% is better than 0%, but if you can avoid the 5%, you can't, it'd be ideal. So think about that, because that often is a surprise to to creditors who aren't as fully fluent in all of this.
Steve, if I might add, this gets even worse when you're dealing with more unusual assets. And, you know, we talk about the excitement of going after show ponies or yachts. The cost to maintain those as you're going through the process,
that's a good point,
can be significant. And, you know, when you talk...
And you can see that right now, for example, with some of these yachts that have been seized from Russian oligarchs.
Exactly.
You know, the governments or other are like, geez, these things cost like $1 million a month to maintain. And, you know, you have to think about that. And again, have a plan, because we've done that, and we've had actually like a crew ready to go to take over these things. And you want to get them sold as fast as humanly possible, which is difficult right now for the frozen oligarch assets, because the government's not really well suited. They're great to freeze, but not so great to liquidate, because you have to get these things, get a crew, and get them into the Mediterranean, where they sell, in the south of France, where they sell all these things.
That's one very important part. And the other thing is with esoteric assets, some cryptocurrencies, you know, when you're dealing with diamonds, you're dealing with other things like that. You also have a situation where if you attempt to monetize at one time, you may actually have adverse effect on the market, and the value will tank.
Right.
And that's, you know, this all goes into the legal strategy. Again, something may be a bright, shiny asset that is, again, unencumbered, looks perfect, but what you do with it after you actually get your hands on it is equally as important.
Right. Sort of like the old saying we have here about the dog catching the car. When the dog catches the car, like, what do you do next? So if we go to the next slide on priority of liens, we want to make sure we're cognizant of getting through our material and getting to questions. So we'll just go through this really quickly. I mean, the first bullet is, in America, pretty much the law, first in time, first in right. There's some exceptions to this, you know, that you need to be mindful of this, and it's often a very important issue. So, you know, look at that, think about it. We'll be happy to answer any questions offline about it later. But that's an important concept of priority of liens, because oftentimes you're not the only one chasing the debtor's assets. So let's talk with our remaining time, if we go to the next slide, about some of the new trends in terms of sanctions, blocked assets, recent developments in cryptocurrencies. So Michael?
Sure. So with sanctions and blocked assets in the United States has taken on a substantial policy of sanctions against recalcitrant countries and trying for policy change. And right now, the largest block of frozen assets that has commercial implications is Venezuela, and there's active litigation in Delaware. And this is a cross current of a lot of different issues. The court's powers to enforce judgments, private creditor rights, and then U.S. foreign policy as being set by the executive branch. Pragmatically, what it means is you know where the assets are. They're frozen, they're blocked, that's helpful to the creditor. But how you're actually going to liquidate it and how priority is going to be sorted out is a complex issue that is coming. There also is a new trend in the United States of terrorism creditors. Those are creditors with a judgment that results from being a victim of terrorism. They are allowed to enforce against blocked assets. And this is sort of the other side of the ledger: Colombian assets, Iranian assets, Cuban assets. And those blocked assets, those plaintiffs are becoming more and more aggressive and looking for third-party financial institutions to try and show some link between the terrorists and the financial institution in order to seize assets.
And again, this is highly topical and very important. And also, as we talked a little bit about before, and as you've seen in the news on the Russian assets, there are a lot of, we call them, the acronym in the U.S. is SDNs, for specially designated nationals. And the list of Russians has been expanding, and that it implicates assets, implicates litigation, their ability to travel, to litigate cases in England right now and in the U.S., but particularly in England. A lot of litigation, licenses are required for lawyers to get paid on litigating against entities that are sanctioned. Oftentimes, the Europeans, the English, and the United States are not completely in sync as to who's sanctioned and who's not. So be very careful with this. You have judgments against these assets, these countries, and or nationals from these countries, and if you want to litigate against them, because it's a very, and every day there's some new development. You really need to have an expert on your payroll who knows this stuff before you get into trouble. And, if you go do these things without a proper license, there are consequences. So if we go to the next slide, just a quick little update on a case that we litigated that was interesting, about reverse veil piercing. Because, veil piercing generally is getting at the assets in a corporate chain, not belonging to the debtor against whom you have a judgment. And you can go one of two ways. You can go up the corporate chain or down the corporate chain. And it's difficult to go up the corporate chain, and, somewhat more commonplace to go down the corporate chain. And here in Delaware, we were able to get this relief in a case that we litigated over the last few years. And, it's illustrative of how it's important to be creative when taking what you have and trying to get the money. And also illustrative of the fact, if you really touch a nerve, like now the company's worried, the entire, both up and down, the entire assets of this entity are available for judgment execution, potentially not against just you, but other debtors who could do this. They take the easy way out and pay. So the bottom line here is be creative, be aggressive, be forceful, all within the bounds of law, and you can hopefully be successful. And if we could go to the next slide, I want to talk about a couple of other developments, most particularly with respect to cryptocurrency and how you can deal with that, because not surprisingly, a lot of judgment debtors have crypto, and what do you do about that? Michael?
So it's always exciting as a judgment enforcement lawyer to look at new assets and new property out there and how to enforce our judgments against it. And it's not just in judgment enforcement law where the law is still being developed, but as we all know, regulators are looking at it. It is a new development, and no one has yet found the perfect analog for something that has evolved for new. Before I get into some of the legal questions, Chris, I thought you could talk about how sort of investigation techniques have come up with this latest asset, and in particular on-ramps and off-ramps, and how that you approach that.
Certainly. So the nice thing is we should be thinking about cryptocurrency as just another asset class, as you did, Michael. The crypto is just like diamonds, just like other things, has its own esoteric rules, but it is just an asset. And the nice thing about it is that unlike the classics of banking and tracing movement, the underlying infrastructure that allows for the movement of cryptocurrency, and its whole definition is about the blockchain, which allows you to see the movement of currency from point A to point B. And so all investigations really tack between doing investigations off the blockchain and on the blockchain. And what we often call on-ramps or off-ramps are that cryptocurrency can't be used everywhere in the world. And so people need to convert it, either convert cash into crypto or crypto back into cash. And in that world is called fiat currency as opposed to cryptocurrency. And so most of the standard investigative dance steps we take, which is deep public records, open source material like social media, and then talking to people then allows you to parlay that into the blockchain and investigations on the blockchain. And so the nice thing about people who are early adopters of cryptocurrency is they tend to chat a lot online, and so social media activity on forums, other things, often can give you the tools and basic tools you need to get onto the blockchain and start doing these investigations. And then once the investigation starts, it's the same kind of dance steps. It's the investigative work, the gumshoe work, and then material given over to lawyers who can use judicial remedies or discovery to get more material. And so as things have evolved in the blockchain, there's a lot more KYC, or know your depositor information. So you can get additional information about the identities behind certain wallets. And then, you can also get additional information about again, the more traditional bank accounts that are often linked to be able to move money into the crypto ecosphere. The second thing, and I mentioned it with regard to the Graylist tool, is in fact Graylist also, in addition to banks, can identify emails that have been associated and whitelisted by some of the larger crypto exchanges. And so again, that also provides you, narrows the universe down to a few likely relationships that you can play with, again, in court proceedings.
Well, that's great. Maybe we go to the next slide. And then, Michael, there have been some developments both in the UK and the US. If you could go through that, and then we'll wrap up and leave a little room for questions.
Sure. In the UK, Steptoe was involved in what we believe to be one of the very first cases of a 2018 High Court decision that issued a freezing order against cryptocurrencies. And in the UK, the law has definitely headed towards the direction of treating cryptocurrencies as property. And if we could go to the next slide, in the United States, it seems to be landing on the same spot where, at least for prejudgment remedies, looking at digital assets as property, one of the most significant unanswered questions so far is whether this is tangible property or intangible property. And that often can come up in terms of certain prejudgment freezing orders or restraining notices. It also can be an issue when it comes to a turnover order. In New York, for instance, tangible property can be brought outside of New York into the jurisdiction, like stock certificates, whereas intangible property, such as money in a bank account, cannot be brought over. And no court yet that I'm aware of, and if there are people out there, I'm happy to chat about this offline, has really decided yet whether cyber assets, and whether it matters if it's on an exchange or if it's a cold wallet, whether it's going to be tangible or intangible. And final point before we turn to questions, on the one hand, when an asset's on the exchange, you at least now have some institution to go after for garnishment purposes. On the other hand, these exchanges so far have been fighting tooth and nail not to be part of any jurisdiction. They try not to house themselves, and they take the legal position, we're not in that particular jurisdiction. And so finding the court that has jurisdiction over the exchange is an evolving issue.
Right, and this is an important issue to keep an eye on, and it shows how, as lawyers, we need to adapt to the different financial structures and how the world around us changes so that we can do our job. So that's a quick run through what we think are some of the most critical elements and thoughts of pre-judgment and post-judgment attachment and judgment recognition. The real takeaway here before we get to questions, Dan, is, as we said, be thoughtful, plan what you're going to do beforehand, implement the plan, be patient, but also be aggressive and innovative. And those are really what you have to do successfully to enforce a judgment against a recalcitrant debtor. So Dan, over to you to maybe triage some questions for us.
Excellent. Thank you very much. And before we move to the Q&A, I just want to say Thank you so much for your time today and your insights. It was an incredibly informative webinar, and I'm sure our audience appreciated that. We have a bit of time for questions now. If you do have a question that you want to submit to the panel, please do submit that question now. But we have a question in from Barry, who asked you to explain proving dissipation against business or living expenses.
Well, that's a good question, because oftentimes I think that's aimed at the English freezing order piece of the dissipation test. They're really, generally speaking, there are two kinds of debtors you're going against here. One is a company, and the others are individuals, and they're very prevalent against individuals, and there's often an allowance set aside for living expenses. And in these cases, it's often litigated how much is enough and whether these living expenses are truly necessary, or whether they're just a tool to dissipate assets and avoid paying the judgment. So Barry, that's a good question, and particularly in cases against individuals, that's something you have to be mindful of and be ready for the debtor to claim what we would imagine is very high expenses. Now, that being said, often these debtors have very expensive assets, houses, yachts, things to maintain, and sometimes you get into a fight with the court, in the court with them. Well, is it really proper to set aside money that, should be frozen to keep up their big yacht or their show ponies? With houses like mortgages, insurance, things like that, and, children's schooling and so on, it's a little bit more difficult to fight them on.
Excellent. Thank you very much for that. We have a second question in from Ricardo. And Ricardo would like you to discuss post-judgment remedies if the judgment debtor has successfully transferred assets to a new company.
Michael, you want to try it?
Sure. So what that often comes down to is a fraudulent transfer. And what you are looking at is, if the assets got transferred to the new company, what was the consideration that came back to your actual judgment debtor? And if the consideration is not adequate, and this often, and Chris has helped me with this, it's a flow chart. And you're always looking, okay, here's the transfer of the assets out from my debtor to some other entity. What came back to my debtor? Because the debtor should be in the same position vis-a-vis the creditor before the transfer and after. Now, often the most challenging circumstance is when a debtor is going to encumber assets, pledge them for securities or loans. And in those cases, you may have to shift the inquiry from whether there was adequate consideration to, was the debtor engaging in this conduct intentionally just to defraud creditors. But that is the best and most well-developed law to chase after a transfer of assets away from your debtor.
And also remember, if it's within the same corporate chain, you have veil piercing potentially available to you. But if it's to a seemingly independent third party, what Michael just described as fraudulent transfers or fraudulent conveyances is your best remedy.
Excellent, thank you. I think that we have time for just one more question. I can see that we still have a good number of people with us. Dorothy asks, I have a US judgment. The debtor is a US citizen but in Dubai. Judgment could not be enforced in the UAE. Debtor has assets to cover my judgment. Can this be recovered through a New York bank, which is a branch of their bank?
So if the bank is in, if you have a U.S. judgment and the bank's in the U.S., I guess it's a UAE bank we're talking about, and if the branch is in New York, there's another little, this sort of provokes discussion of a doctrine that's important to remember, which is the separate entity doctrine. It's very unique and is really judge-made in New York to protect financial institutions. So assuming this hypothetical is it's a UAE bank with a branch in New York, and that bank is holding the money. If the bank will likely take the position that the branch in New York is a separate entity from the UAE bank, and that as a result, you can't get after the assets or even get discovery of information that resides in the UAE. If the money is actually in the New York branch, that's different. But if it's separately held in the UAE, you could have a problem.
Brilliant. Thank you, Stephen. And what I would advise Dorothy to do is get in touch with our panel, who I'm sure would be happy to discuss in more detail your question. And that goes for anybody that has joined today. And if you have a question and if we haven't unfortunately been able to get to it, I do encourage you to get in touch. But looking at the time, I think for now I will say thank you very much to our panel. Once again, you have their contact information there. Thank you very much for your insights today. Stephen, you did a fantastic job at the end, just summarizing everything and giving us some key takeaways. I don't know if I can hand over to you to close off today's webinar and give any last minute advice that you would like to do.
Sure, thank you very much, and thank you for your attention and participation, and we're happy to answer any questions offline, and we would encourage you to seek us out. I think the only other point I would add from our sort of overall to-dos is, as you've seen, the law evolves, the kind of financial elements and the ways people hold money, conceal money, secrete money changes all the time. So stay on top of things and consult an expert in the field, a lawyer and an asset chaser. So thanks very much.